Yes, why?
Steps, but taken is not
We'll let the matter reach, we'll pass orders.
license.
Yes, madam.
Maybe listed for admission on.
This matter is, you will have to go, what is that matter?
Matter is a criminal revision petition.
You will have
in
to
the-
go before the senior bench and mention. Yes. He is a railway contractor also, this man. List this matter before any other bench without me. I had appeared for him.
Immediately.
Hmm.
Not sure I'm pressing the matter because
He has expired.
expired.
Mr.
That alone.
Z. Alam, learned counsel for the petitioner, on instruction submit that the sole respondent, accused, Anil Kumar Bora, during the pendency of the present proceedings, had, do you have the date?
Sir.
Had passed on, on 7th? 7/3. Oh, there is a report.
Report.
7/3/2025. So accordingly, he submits that the present appeal has
Petition.
been abated, stands abated, full stop. Prayer is not objected to by Mr. R.J. Burwa, learned counsel for the learned additional public prosecutor appearing for the state. Full stop. In view of the above position, the present appeal stands closed on being abated.
If
There is a legal aid counsel also not appearing. Do you know her? M. Das. আছে নেকি নাম? M. Das কোন হয় চোৱাচোন? নালাগে তুমি লিষ্ট এটা আছে নহয়। This will be the legal aid, it will be different. And why are they not appearing once they have taken a matter? We'll take it up after some time. If not, we will appoint somebody. Even in criminal revision petition, we will have to appoint an amicus curiae, or we can dismiss this. Huh? Revision can be. Appeal cannot. Okay. Consistent. And PW1 and PW2 have corroborated each other. PW3, he is the subsequent, he came to that place, but he corroborates with regard to the injury, and the medical officer's evidence is also. So this can be disposed of even without the none appears for the petitioner on call. But Mr. MP Goswami, learned additional public prosecutor. So, Ali Murkane likhisa de to. To be taught him. Criminal revision petition stands dismissed. I go to some. I to appeal hai na lage. What has happened, ma'am? You have stopped the petitioners from appellants from coming to the court. This is not good. No, we also came. Can't say studied, but we have perused. That was forged. Yes, madam.
I'm appearing.
Huh? Hmm. Huh. One judgment, huh? Yes.
My senior will appear in this matter.
We have not stopped him, have we? Or madam has stopped him. Then? Why was there not a note circulated? Not accepted. You do the matter. Have you read the brief? How long have you been in practice? 2 years. Long time. And what about the others? Mr. N. Mahmud, I think he's Noor Mahmud. Unfortunately, I think he has passed away. Who is Mrs. S. Yasmin? Where is Mr. Kumar?
So station your
When is he coming back?
ID.
What to do? No, my hands are tied because without them I can't do this. These are appeals. We'll have it on Monday. Monday next. No further adjournments. Kak Dew, whom should I appoint? He's not here. Item number 5, 6, 7, 8, 10. The present appeals have been instituted. Acyclic, a common judgment and order dated 7/10/2013 passed by the special judge, CBI, Assam in special case number 160/2004. Also, on call, none has appeared for the petitioner, for the appellants. Also, in view of the above position, anybody interested? CBI appeal, small point. Anybody interested? Sir, you're too senior. You're too senior. Some juniors I want. Anybody? Come. You prepare one matter, the other matters will get automatically resolved. Mr. Kumar is also there. Same judgment, small point. It's with regard to an LIC policy, a loan sanctioned against an fraudulent LIC policy. Just see. Madam is also there. Huh? Your name?
A. Rahman.
Mr. A. Rahman, Learned Counsel for the Learned Counsel of this court, on being requested, has consented to act as the amicus curiae in the above noted cases. Huh? Accordingly, the courtmaster shall furnish a copy of the appeal memo to Mr. So-and-so, Namdu, during the course of the day. Raised it to list these matters again on Monday, 22, along with criminal appeal number 3 We can't help it. We'll appoint him also for that case then. 2013 matters, madam, we are not going to deal it in this manner. He should be here or make alternative arrangements. 388-2023, Tuesday ko idea. Tuesday, huh? Tuesday. Madam, Tuesday is fine with you? Tuesday. It would likha 388-2013. A prayer is made on behalf of Mr. B.D. for an accommodation in the matter on the ground that he is out of station. The matter is of 2013. However, in the analogous matters, there being no representation, this court had fixed the said matters on 22/9/2025 by appointing an amicus curiae in the matter. Accordingly, the present appeal be also taken up on 22/9/2025 along with the other analogous matters listed on the same day. Full stop. We go. 23, huh? 20. And that she will end up.
For the timing, Lordship.
Why? Okay. But not, we will take it up immediately after the motion item. Hmm. .366 was there. 363 was established. So under 363, he was punished. And the trial court's judgment on appeal was also upheld. The only contention was that being the charge being framed under 366, it could not have been converted to 363. 222 CRPC. There is no bar.
There is no.
None appears for the petition on call. Heard Mr. MP Goswami, learned counsel for
Because
the
the victim's age, and that is, my lord, exhibit 2 is the victim's.
certificate that has not been disputed. How do I ensure that this copy will be sent to the trial court? Because he'll have to surrender. I'll direct him to surrender.
Yes. Then
Who will ensure? The trial court.
trial court. Yes.
Dismissed. Dismissed.
Senior.
Why?
Like, 10 days conviction.
Man has retired by now.
Yes, Lordship. 74 years, Lordship.
And maybe imposed, my lord.
Huh?
And maybe imposed, my lord.
See, there is a gap in the matter. His categorical statement is that he had not received the notices.
Lordship.
DSP and the reserve officer had made statements that they had sent it. The sending is there. But that receipt signature of he disputed that also. In that view of the matter, maybe, but this aspect was not looked into. You go through the evidence once.
W2 is clearly stated, Your Lordship. I cannot recognize the signature of the person receive it and from the exhibit.
Exhibit 4 sending both the DSP as well as the reserve officer said. Now, the reserve officer had also made a statement that he had informed him telephonically. But that call records were not exhibited. No, still, your intimation to you,
Your lordship.
intimation given to you that you also was a bit haughty of a character. You also, what
I'm not gaining something
we'll see.
for lordship.
You're getting your pensions?
Lordship.
We'll see.
Item number 4, Lordship. Another set of advocates used up us, Lordship. So
We have
they are-
dismissed it. Mr. Singha, you are there in item number 4. We have dismissed it.
I was badly stuck in the traffic jam, my lord.
Okay, we'll take it up. You be here.
My lord, kindly add 2, my lord.
Two. Do you think this court will be sustaining till 2 o'clock?
No. Then my lord, Friday, because
I can
my lord,
dictate the orders at that. No, today itself. After some time, you get
my
your
lord,
breath
I don't
back.
have the file because my lord, this is a long.
Hey,
time.
say file given.
Yes,
PW1 and PW2, husband, wife, husband beaten up. PW2 informant. PW3 witnesses the injuries. What is more is required? The police, the medical report also is corroborating the evidences on the head and the left arm. You try to make out a case for some sympathy.
Parties are not there, my
Thank you. Yes, 25.
20
Jawar asil dumanu. Or none appears. Oh, Mahazan, sir. N. Mahazan. Can somebody inform Mr. N. Mahazan? Put in.
Earlier filed one maintenance case of Dhubari.
EV case. That has been disposed of.
Getting maintenance.
You are paying her.
That is pending for
You have not
Payment.
paid her till now.
not started, but payment will be
Mr. Counsel,
started. Madam.
to cut the matter short,
But
therein under section 19, she was not given an alternative accommodation by you. Because she said she has enough. She has a means to live. Where is her parental home?
Paksa.
Paksa or Nalbari? Why have you not disclosed that? You have also, in the present revision petition, her address is Nalbari. Page 2.
Come to page 11.
At that point of time, she was staying in your house only.
No.
Evidence is there.
Current house on rent.
Bidad as it may, it was there, but
Till
there she left now. You come to para 20, page 25. I want to know where is her parental home. And
kindly come to page 28. Your Lord.
this is Nalbari.
Here she stated her parental house.
So this is her parental house. Mr. Counsel, is this her parental house?
My lord, here permanent address is
Ah.
Paksa in the district of present address Nalbari district.
Okay. But Mr.
Here.
A?
Here, Rahman.
A. Rahman, learning counsel for the petitioner. So, the present application has been instituted under section 447 of the Bharatiya Nagrik Suraksha Sanhita, bracketed BNSS, 2023, praying for transferring the case instituted by the opposite party under section 144 BNSS, presently pending before the court of the principal judge, before the principal judge family court Nalbari, to any court within the district of Dhubri, to any court of competent jurisdiction situated in the district of Dhubri. So, the petitioner in the present proceeding has submitted that the opposite party had earlier instituted a case under the provisions of Section 12 of the Protection of Women from Domestic Violence Act 2005 before the Court of the Judicial Magistrate, First Class, Dhubri. The said case was disposed of on 25/2025. So, pursuant to disposal of the said case, the opposite party had instituted the proceedings under Section 144 of BNSS 2023 for granting maintenance to herself and to her minor daughter before the court of the principal judge family court Nalbari. Also, subpara. The learned counsel for the petitioner has submitted that the petitioner was residing at Dhubri and her parental home is situated in village Madhapur, Madhapur, in the district of Baska. However, only with the view to harass the petitioner herein, she had instituted the present proceeding at Nalbari. Also, in view of the said submissions of the learned counsel for the petitioner, the matter, this court is of the considered view that the matter would require a closer examination, which would be permissible only on the appearance of the opposite party in the matter. Full stop. Issue notice, returnable 4 weeks. Petitioner to take steps for service of notice upon the opposite respondent by way of registered post with 80 steps within 2 working days from today. Full stop. Pending further consideration of the matter upon appearance of the respondent in the present proceedings, further proceedings in, what is the case number?
86/20.
Further case proceedings in
Your Lordship.
notice
Order sheet I have pendings.
in maintenance case bracketed U/S 144 of BNSS bracket over /86/2025 pending before the principal judge family court, Nalbari shall remain suspended. Yes, Mr. Monta, any development? Let Mr. Nat will have better interest. Let him come. Yes.
Lord, we took the instruction, my lord. The mother of the son, my lord, the respondent.
Now, how could you make this statement on the last date that he is not in a condition to appear? He is not in a condition. The court order is somebody will take him. Somebody will take him. Why? Come and see. Come to para 12 of the order dated 22/7/2024.
This order was passed 1 year back, my lord.
Be that as it may,
Whatever it is. As this order has been passed in the. This is, my lord, at that point of time, it is done, my lord. But guardian, family, whoever they will assist her, him to.
we only want, he cannot go on his own. Fine, we understood.
But there is.
But his family members cannot take him. Where is the material?
But his mother is only there, my lord, who is 9 years old.
He would have, he has got nobody else in his, in his life.
Nobody is coming, my lord.
Then take back his daughter. Daughter is the best time to
Yes, my lord.
ask him to take his daughter back, make her his heir. He has nobody. So the
Lordship
daughter will
was-
go back. She will also get the care and love of the father, and the father will get the assistance of the daughter. How old is she now?
He's reading in class 9, my lord.
9. Very good.
Whatever lordship passes, we obey the order, my lord.
No. First, I want this order to be opened. Why?
There is,
Mr. Roy, this order is very clear.
lord, the question.
Guardian family members, you make a statement that other than the mother,
This is one.
there is nobody.
This statement we make 1 year back, my lord.
You make it now.
Can't do it, but we.
I'll ask the police to get him to the.
Yes, lordship, my duty.
Hmm?
Lordship, my duty.
And my lord, your lordship may please to direct the family members, my lord, as they are very rich peoples, my lord. Having, my lord, so many markets, my lord, all.
I know.
Whatever.
I know.
I leave it to your lordship. Lordship may pass any order. Any order, lordship, because.
I'm recording your statement. That in view of the thing, Mr. Roy submits that he has only his mother and nobody else in this world.
Is there?
No, you made your statement. Nobody else in the world, and accordingly, he will comply with whatever order this court passes. And I'm going to pass an order that his daughter will go back to him,
Yes,
stay with him, and will be his heir.
yes.
You challenge wherever you want.
Lordship can do that, but.
I'll say that it's your consent.
No, lordship is say that there is that statement. I have not made it, my lord, that there is no one in the family. There is everyone in the family, but nobody is cooperating. Nobody is with the his brother, my lord.
Means he is alone,
He's alone with his
mother. So get back your daughter.
I said to lordship.
We'll have it at 2 o'clock. You get your instructions.
I don't think somebody is possible.
Where is he? Where is this?
He is
Got you?
Morigaon,
Huh?
Morigaon.
Morigaon. We'll have it tomorrow. Take back his daughter, the end of the matter.
Whatever lordship.
Provide for everything for the daughter. Daughter will also take care of the father. Any issue? No issue?
As my lord, he is, my lord, now, my lord, communicating to his minor daughter, my lord, by through WhatsApp message, my lord. And informing that his birthday was on, my lord, 13 September, my lord.
Okay, there
So
is.
he is communicating, my lord, his
I don't know.
daughter, my lord.
That
Why don't you resolve the issue then?
Actually, my lord,
I told them I had to go to that Morigaon house to find out that what is his
how
condition.
can I go, my lord, without any orders from this court?
Yes, let there be an order from the court. Let
That,
us
we
see
can go
that
something.
whether it is possible or not. I'll be glad to see that, my lord. Let her go, my lord. I told many times I've given the suggestion that you go and see yourself. Because we also don't know, my lord. We are on certain instruction from here and there, my lord. And this
Are you not in touch with the petitioner? Then who is
her mother-
instructing you?
Sometimes her mother or sometimes, my lord, she also doesn't understand. But someone from her relative, but they are not cooperating so far because nobody wants to take this. This is
Also, my
peculiar
lord,
case, my
only grandmother of the minor daughter is here, my lord. She is also 79 years. He is taking care of, my lord, the minor daughter of the.
Actually, seeing his mental condition, they have abandoned, my lord. If lordship may send a team of either doctors, advocates, whatever it is, my lord.
Now, this order not being complied with, what should this court do?
Just
Madam,
My lord, they have taken, my lord, the counsel taken plea of the mentally.
that plea is again supported by his termination by
Yes,
the State Bank authorities. So there is something, but this court wanted it to be conclusive.
Yes, my lord. As my lord, all because of this case, my lord, my minor daughter is my lord, suffering, my lord. Suffering, my lord.
But in
the
the
midst
meantime, my
of
lord, she didn't say, my lord, since last 1 year, from her mother's account, 5,000 rupees from her pension. It is paid to her, the daughter, my lord.
since 1
Since
year,
1
my
year.
lord.
The grandmother is paying. And what about the landed properties and all? How is been devolved?
All or by his brother's seeing his
So the area
mental
amount is
condition.
a normal more.
13
Mental
lakhs.
condition, my lord, has been, your lordship. This is a very
Property.
peculiar case, my lord. We are also doing pro bono, my lord.
Now, tomorrow, if he comes out, it comes out that he is really mentally unstable. Then what would be the effect of this case?
Direct the family members to take him.
That would be the best advice from your lordship, like.
To the family
If
members.
they take our daughter with the family, but I don't know matter whether
That I can't pass now in this proceeding.
lordship, definitely my lordship is, set a team of either officials, whatever, my lord, lordship.
Heard Mr. J. Roy, Learned Senior Counsel, assisted by Ms. B. Shah, Learned Counsel for the petitioner. Also heard Mr. R.B. M.B. Goswami, Learned Additional Public Prosecutor, appearing for the state respondent. Also heard Ms. B. Saikya, Learned Counsel for the respondent number 2, representing the granddaughter of her elder daughter, namely Aisha Rahman. This court had wide order dated 22/7/2024, on consideration of the issue arising in the matter, passed the following direction. Para 9, 10, 11, 12. Also, the matter was thereafter not listed for a considerable period of time and was listed again on 3/9/2025. Also, on 3/9/2025, this court had recorded the submission of Mr. J. Roy, Learned Senior Counsel, for the petitioner to the effect that the petitioner is not in a condition to attend the medical board as constituted in pursuance to the directions passed by this court vide the order dated 22/7/2024. Full stop. Full stop. This court finds that the petitioner in the present proceedings has taken a plea of insanity. However, the same is not established in the matter, and accordingly, this court had passed the directions as noticed above vide the order dated 22/7/2024. Also, Mr. J. Roy, Learned Counsel for the Learned Senior Counsel, appearing for the petitioner, has submitted that the petitioner's condition is not such that he can on his own proceed to appear before the medical board, and he would require assistance for the said purpose. He further submits that the relatives of the petitioner have all abandoned him, and he is now presently staying with his aged with his mother, who is around
8 to 90 years.
who is around 90 years of age. Also, in view of the above position, this court requests the principal cum superintendent, Guwahati Medical College and Hospital, Guwahati, to constitute a medical board in terms of the directions passed by this court-wide order dated 22/7/2024. And requires the petitioner to be produced before the said board. Give me a date.
He did, my lord.
We'll put it after the vacations. Before the said board on 15/10/2025 at 11 a.m. So, the learned counsel assisting Mr. J. Roy is required to inform the petitioner and his family members about the directions passed by this court today in the present order. Also, in the event the family members are not in a position to accompany the petitioner for appearing before the medical board as constituted at the Guwahati Medical College and Hospital, Guwahati, they shall inform the matter to the Superintendent of Police, Murigaon. Also, on such intimation being given to the Superintendent of Police, Murigaon, the Superintendent of Police, Murigaon is requested to provide for the necessary escort to the petitioner and to get him and to produce him before the necessary assistance to the petitioner to facilitate his appearance before the said medical board on 15/10/2025. A copy of this order be forwarded to the Superintendent of Police, Murigaon, by the learned additional. Mr. Goswami, forward a copy to the Superintendent of Police, Murigaon. Superintendent of Police, Murigaon, by Mr. M.P. Goswami, learned additional public prosecutor. First of all, Mr. D. Upamanu, learned standing counsel, Health and Family Welfare Department, who is present, has undertaken to communicate the order to the principal cum superintendent, Guwahati Medical College and Hospital, Guwahati, for necessary compliance. Also, subpara. On the petitioner being examined by the medical board as constituted, widely order dated 22/7/2024, a report thereof shall be furnished before this court in a seal cover through the learned, through Mr. D. Upamanu, learned standing counsel, Health and Family Welfare Department, on the next date of listing. Also, registry to list this matter again on 22/10/2025. Also, this court, considering the submissions made by the learned counsel for the petitioner, for the parties who have submitted that they would it is further provided that given the nature of the proceedings given the nature of the proceedings pending before this court, there would be no bar for the father and the daughter to communicate with each other as well as to meet each other. Done?
One thing what I must say, my lord, order dated 22/7, uploaded a month ago. That is what the problem is, my lord.
Mr. Boroy, What is past is past. Let us see
very-
for the future.
But I just want to point it out.
And this order, I don't want compliance. I want the compliance of the last part.
Last part, I also want, my lord. This is very unfortunate case, my lord,
If
because
the earlier part is not complied with also and the subsequent part, meeting, staying together is complied with, I'll be happy.
Right. I
We
also want-
will close this.
I also want. I also want.
You know,
Item 18 may be fast timing, my lord.
why?
The A. Ahmed is on lag in court number 2, my lord.
Yes, Mr. Purkhaista, what has happened?
Chief charge sheet has been filed subsequently, not on that date, but it has been filed.
Oh.
That ground, it may not be closed, Lordship.
Now that I'll have to close it on that ground because it will be taken up by that court in accordance with law.
There will be some,
Have you challenged that? You can't challenge that charge sheet.
no, I cannot challenge it. Now, because Lordship, be the ground for,
No, why should I? This is handing over the.
no, I am not
Then-
insisting upon, because CBI has filed earlier affidavit also, that saying that they, I have a copy of this.
They have
They are
filed an
not-
affidavit. But once the charge sheet, your case is that matter was not being taken up. Now the matter has been taken to its logical
My case
conclusion.
was that the
Investigation.
proper investigation was not done.
That is for not for this court to look into. When there is a challenge to that, we will see.
Because Supreme
Now
Court,
the charge sheet is also involving the.
as per number 11,
Huh?
only one person. There is no investigation to the bank's part. Because my property is, because I have been raised as mortgage.
I'll give you liberty. You take up any issue that is there with the authorities or with the inappropriate forum. Any grievance is there, you take it up. That much I'll give. Mr. S.D. Purkhaista, learned counsel for the petitioner, on instructions, has confirmed that the charge sheet in the matter was filed by the investigating agency. Also, the charge sheet in the matter, charge sheet in reference to Silchar PS case number 960/2022 having been filed before the competent court on 31/7/2025. This court is of the considered view that the grievance raised by the petitioner or having raised by the petitioner in the present proceedings would stand redressed. Also, Mr. S.D. Purkhaista, learned counsel for the petitioner, has submitted that the petitioner would have further grievance with regard to the manner in which the investigations were carried out. It was your FIR
It's my,
in pursuance to the information lodged by him before the police. Also, it is provided that the said aspect of the matter can be agitated by the petitioner by instituting appropriate proceedings in accordance with law, if permissible. In accordance with law. Instituting appropriate proceedings in accordance with law. So, insofar as the present proceedings is concerned, this court is of the considered view that the matter be not detained in view of the filing of the charge sheet in the matter, and accordingly, the present writ petition stands closed.
handed over a copy of the list. Monthly statement from the year 2017. Before that, they have not provided.
You pay from 2017, we'll see the before part. You pay. Now you have got it, pay. Ben, how long will it take you to pay? I'll provide for that also. Installments. How many? 2, 3?
Because-
No, you have talked. No more talking. Now action.
Lordship, kindly say before 2000.
You had, your grievance was the breakup was not given. We ensured that the breakup is given to you.
No, still it is not given, Lordship.
From 2017, it is given.
Before 17, it is not there.
Okay. We'll say,
Let them, Lordship.
forget it. Before 17, why have you not asked? Have you asked before that?
Yes, Lordship.
When?
I have prayed for the.
When? When did you pray?
In my writ petition, Lordship, I have
How
stated.
much were you paying from 2000, before, prior to, you have not been paying anything.
Since 1961.
61 lakhs is there. How much will you immediately pay? 50% you pay, rest.
Lordship,
Give him the breakup also. Take 30, give him. You want the money? Huh?
At 2.
No, today, no.
At 2, Lord.
At 2, it will be 40 lakhs. You had too much liberty given to you.
Yeah, 2, Lordship.
At 1, before 1. Mr. Samaria, take what is paying 30,000, 30 lakh, 50%, give him the breakup, and then on the next day, we'll give you the other part also. Mr. Doctor, there is a limit. Tell your client.
I'll go.
If not, we'll pass a mandamus with interest. Madam, why these matters are being
Yes,
kept
yeah.
pending like this? Madam, I'm not talking to you, I'm
So-
talking
so
to
that is
CBI.
Taking care of, I have come to know, your lordship, the name of the PK Singson has wrongly inserted. He has died at the time.
No, he is already deleted.
So
That-
Already deleted.
we
That
have
is done
sent
by
IA
18/1,
to delete
2021.
his name.
You have all that deleted. PK Singh is no longer a party here. He is already deleted.
Then
On 28/1/2021, that correction was made in
That's
terms of order dated 18/1/2021.
21.
Madam, this very casualness of your agency is coming out here.
I am taking care of
Very
this so that
badly
it will
being conducted.
be in the streamline.
Very badly being conducted. You are not sure who are the parties alive. You are not sure who. And these orders were passed way back 18/8/2025. One order is passed. In the meantime, one of the opposite party has expired. That an interlocutory application would be filed. No interlocutory application till today. Who is that party? Yes, Mr. Das.
I filed a affidavit, my lord, with regard to the continuation of delay, my lord.
Hmm.
My lord, here you also will find that the judgment was delivered on 14/6/2000.
Hmm. Hmm.
And affidavit was sworn, yes, 14/6/2018, my lord.
Affidavit was sworn on
And the
17/12.
And the appeal was filed on 23/12/20. And from 23/12/8/20, my lord, the matter is pending. Yeah.
Doesn't show in very good light, madam. This is not expected.
There is,
Assure, I
Huge-
will take care and I will bring in the streamline.
Ma'am,
your
before I had
lordship.
taken, I did not have much experience with this conduct of
Yes,
these
the
matters.
Delay
But
condonation.
after I have taken up, I find that the state is better placed, at least for the matters which have come before me. A premier agency, this sort of conduct,
two judges of this honorable court, my lord, coordinate judge.
I can dismiss it. There is no problem. But,
There, of course.
and madam,
Cat and off cases.
madam,
there are
see the casualness. See the casualness. Delay is to be explained till which date? Filing of the date. If what Mr. Das has submitted, that the affidavit is of 17/12/2020 and the appeal is filed on 23/12/2020, where is the explanation for these 5 days? It cannot be there. This is a height.
It is a recent judgment of the Supreme Court, my lord.
You place that. I'm not putting madam into trouble because she has just come in. We will have it on Monday. Monday. This Monday. Next Monday. Because this week you are having some problem. So next Monday. And madam, this thing has to be resolved or we are going to dismiss it. And we will record these things in the order. That may not be very palatable. I can understand. That's why I'm giving you time. If it was the counsel who had filed it, I would not have given. Now that you have come in, you have said, madam, you go through the thing, resolve what is to be done. On Monday, no further adjournment. And Mr. Das, you place those judgments on that.
My this government servant, my lord, they have spent their entire life only on nothing else. 22 years, you also be consistency.
We'll take care of that. Don't worry. Heard Madam M. Kubari, MS M. Kubari, Learned Standing Counsel, CBI. Also heard Mr. D.K. Das, Learned Senior Counsel, assisted by Mr. P. Borman, Learned Borburwa, P. Borburwa, Learned Counsel, appearing for the respondents. But all cases, all one case only in item number for the respondents. Full stop. Ms. Kumari, M. Kumari, Learned Standing Counsel, as CBI has submitted that she has been engaged in the matter recently and accordingly prays that she be given a week's time to examine the matter. Prayer accepted. Registry to list this matter again on IA to Maripade, IA criminal bottom to this matter again on 22nd, 22/9/2025. It is provided that no further adjournment would be granted in matter IA criminal.
Please, Lord.
Hmm.
My lord, I'll insist upon my lord, the IA, my lord. Here is the case, my lord. The petitioner was
Got it, Mr. Barbuya.
lordship.
The notices have been served, but there is no representation on behalf of the informant, victim. Okay. So what we do is we direct the registry to appoint a legal aid counsel here.
Maybe fix, I'm behind the bar for more than 4.5
We'll consider.
months.
We'll consider. And now the record is, we can hear the matter.
Yes, that also will do, man.
We'll appoint somebody and we'll hear the matter. Why is this interim business?
Yes.
If you are out for the.
Yes, I'm either.
This is that girl who was kidnapped in a Maruti van.
My lord, that was not proof.
Then she was gagged with her own clothes.
No, my lord, there is no prima facie, my lord. Only basing on the assumption I was.
The prosecutrix witnesses evidence is.
No, my lord, there is a shaky between my lord 164 and the FIR.
That you will have to argue.
Yes, my lord.
That you will have to argue. This is a matter of 21.
My lord.
Insects have come in only. 13 files is full of insects. But now I find the 21 file is also having insects. When I open the files in my chamber, things start flying. Things start flying. 2013 matters. Many things come out.
Because
Okay.
lordship, only one thing, my lord, shortage may be fixed, my lord, for entire
it is seen
disposal, my lord.
that the notice was served on the respondent number 2, that is the victim. However, there is no representation on behalf of the respondent number 2 in the matter. Accordingly, registry is directed to appoint a legal aid counsel for the respondent number 2 and list the matter on the next date of listing by reflecting the name of such legal aid counsel appointed in the matter. Registry to list this matter again on 15/10/2025. Full stop. as
My lord, can it be, my lord, 15 other matter is fixed, my lord.
13,
Yes.
14, 16?
16.
16, 10,
Right.
2025. Who's up? Shall we take it up for hearing that day?
But only one observation be given and over to be made to dispose of, man. That will cover everything.
No, that is in the criminal appeal. A criminal appeal at Maribode. Who's up? As the lower court records have been received, comma, the learned counsel for the parties have submitted that the criminal appeal be taken up for disposal. Full stop. Accordingly, a registry to list this matter again on 16/10/2025.
One observation and over to be made to.
That we'll see on that day. Really? এইটো তো মোৰ তাত মানে একদম ভূমি ভাই ওলাই থাকে পুৰণা ফাইল তাত
Please, madam. The law, trial court records are service. Service is
Service is complete. Nobody has appeared. Will have to be. Let the registry appoint. You are appearing. Your name Gupta. Why was the legal aid counsel appointed here?
earlier filed by the legal aid counsel. Later on, my lord, they
But Mr. A.K. Gupta, learned counsel for the petition for the appellant, and Mr. M.P. Goswami, learned additional public prosecutor, appearing for the state. So, the office note reflects that the office note dated 15/5/2025 reflects that the notice has been duly served upon the respondent number 2. Respondent number 2. Also, the trial court records have also been received. Also, as there is none representing the respondent number 2, registry is directed to appoint a legal aid counsel for the respondent number 2, represent the respondent number 2, and list the matter on the next date of listing by reflecting the name of such legal aid counsel in the cost list. Full stop. Registry to list this matter again on 23/10/2025 for admission hearing. For hearing. For hearing.
Lordship. Lordship, as per office note dated 10/9, Lordship, neither return back, Lordship.
In the office note dated 10/9/2025, neither AD card nor the unserved notice has been received, but for the service report in respect of the notice issued to the sole respondent through the office of the district magistrate Dibrugarh has also not been received back. Also, in view of the above, petitioner to take fresh steps for service of notice upon the respondent number through by way of registered post with AD as well as by way of usual process for steps within 2 working days from today. Registry to list this matter after 4 weeks along with a report with regard to the service of notice upon the respondent number 2.
Like,
There is an interim order. Interim order passed earlier to continue till the next date of listing. Material 9. Seen the office note dated 10/9/2025, which reflects that the notice sent up to the respondent number 2 by way of registered post has been returned back as unserved with the remark, postal remark, apostrophe, refused by the addressee, apostrophe over. However, the notice issued to the district magistrate Borpeta. However, a report with regard to the notice issued through the district magistrate Borpeta has not been received. The said notice was indicated to have been issued only on 27/8/2025. The registry to list this matter again after 4 weeks, along with a report with regard to the service of notice upon the sole respondent through the district, through the establishment of the district magistrate Borpeta. Also, interim orders passed earlier to continue till the next date of listing. There was a no problems. None has appeared on behalf of the appellant, even on second call. Also, Mr. Burwa, give me a name, somebody. Yes, Mr. No, next. Yes. What is your full name? Dhruva Bora. Mr. Dhruva Bora, learned counsel of this court, on being requested, has given his consent to act as an amicus curiae in the matter for the appellant. Also, courtmaster to furnish a copy of the paper book to Mr. Bora during the course of the day. A registry to list this matter again. You're not putting it, we'll take it this week only.
Day after tomorrow.
Day after tomorrow. On Wednesday. Your amicus curiae, your name will come now on Wednesday, 17/9/2025. Registry to list this matter by reflecting the name of Mr. D. Bora as amicus curiae in the matter. Yeah, sir. Paper book to us in detail. It's with regard to a 4-year-old girl. What you have to examine basically is the 4-year-old 164 statement was there. Mother, father, others have given, but they are not the eyewitness. There was a Bisar. In the Bisar also, the evidence is that he confessed, for which a garland of slippers were made, be that as it may. But this girl, during her examination in the trial, she could not say anything. And after the judge, session judge had examined her by that normal questions, found her not to be very cooperative, maybe because of the incident or something. So her evidence was ignored, and the conviction was on the basis of the medical examination, mother's evidence basically, and the respond number 3 and 4. So just examine as to what would happen if that gap is there. Okay. Yes,
My lord, I've gone through the records.
nothing is there.
Now, no, my lord, of the records, but it seems that the IO, my lord, the IO and the medical officer was not examined in the trial.
How does it prejudice
My
you?
lord, that is true. That is not fatal, my lord. That may not be a fatal, my lord. But in some cases, my lord,
Huh?
Doctor.
PW4 is doctor. But Dr. IO was not examined.
not examined, sorry, my lord.
IO was not.
In some cases,
Doctor.
non-examination of the IO is not fatal in some cases, but in some cases it is required. My lord,
How?
my
Show
lord,
me.
kindly see in this case, my lord, I have gone through the my lord, and cross of the PW1. Now PW1 has stated that incident was in 1:30 p.m. Now the second PW2, my lord, PW2 is the wife. Now, in their, my lord, evidence, they have specifically stated that both are there when the incident was occurred. So PW2 said that the incident was happened in 1 p.m. My lord, that
See,
is
the deposition is made. The incident is of 9/10/2005. The deposition was sometime in
after 5 years,
5 years.
my lord.
So this minor contradictions
No,
will
my lord,
not be.
one contradiction.
We will take it.
My lord. And the PW3, my lord, the independent witness, my lord.
Okay,
He
Mr.
stated-
Singha. One. Contradiction with the deposition of PW1, who is the informant,
No, one is the, my lord, the victim,
victim, and PW2.
the wife, my lord, of the victim. And also, my lord, the 3.
Hmm.
Now, 3 is the independent witness, my lord.
Hmm.
He was there when the wife, that means PW2, shouted, my lord, at that point of time.
Then he came, when he came out, he saw.
Now, his statement was that he never seen anything on that place.
He does not, he
Yes,
does
yes.
not say about
But
the,
as per his evidence, my lord, the incident was happened at 12.
okay. And in the FIR, the disclosure is 1 p.m.
1 p.m. Now, the victim has said at 1:30, informant said at 1, and my lord, the independent witness said at 12. And now kindly see in the PW2 witness, it is specifically stated that the assault was made by accused number 2, not by 1.
Accused number 1 caught him. Accused number 2 blowed, given a
In his cross, my lord, in her cross, my lord, it is very specific that assault was made by 2.
But her husband was caught by the PW1, and PW2 had thereafter stuck him first in the head, then in the left hand.
PW1 said, my lord, assaulted by both.
Hmm.
Assaulted by both, and PW2 said that assaulted by only 2. My lord, kindly see the cross, my lord, cross part.
Hmm.
There is a contradiction, my lord.
Okay. But that incident is there. Hmm.
That's why, my lord, I'm saying, my lord, my submission, my lord,
Hmm.
since there is a contradiction in between the evidence, my lord, of PW1, 2, and 3.
Hmm.
So in that case, my lord, the examination of IO was, my lord, necessary. Because the examination, the report of the IO, that will clear whether that incident took place or not. Because no other eyewitnesses there, my lord, whether that incident took place on that time or that assault was made by the accused. Only, my lord, the informant and the victim.
You want the records, Mr. Gusami?
Because if just I want to see that she
Then, next.
So that's why, my lord, if the IO statement was taken, my lord, in that case, that will clear whether the incident was happened on that time.
What is the time in the charge sheet?
Charge sheet, my lord, like what is
FIR, it is 1 p.m.
Well, FIR is 1 p.m. Now FIR is lodged by the wife, but victim said it is at 1:30. And the independent witness who was
1 o'clock. Charge sheet also.
charge sheet.
Hmm.
So, my lord, and the independent witness, my lord, who was present there on the shouting of the PW2, he said the incident was happened at 12. So there is no corroboration of timing between these 3 witnesses, my lord.
Hmm.
That's why, my lord, the importance of this IO statement was very not necessary in this case, and that was not taken. Because IO's, my lord, report or evidence will prove that whether that incident was happened on that day or not. Because that may be a mere allegation, my lord. There must be some incident, my lord. That may be a, my lord, normal incident. Because there is no other parties or
Mm.
persons who,
Mm.
my lord, who was the eyewitness of that incident or of that assault by the
Mm.
accused.
Hmm.
Only the wife said and the informant, my lord, victim said.
Now the punishment is 1 year,
1 year, my lord.
6,000 and 500 for 341. So this is your submission.
My lord.
Okay. Anything more?
No, my lord, one thing, my lord. Number one is already in bed. Is more than 37. And already, my lord, his case may be kindly considered because in the PW2 witness, it is very clear that the assault was made by the accused number 2, not by 1.
Accused, what is his name?
Accused number 1 is, I think, my lord, Pulo Singha, and accused number 2 is Santo Singha.
How old is he now?
But as per my knowledge, he is more than the accused number 1 is.
And accused number 2?
Maybe, my lord, 45, 50. Maybe 45, my lord.
So he caused the attack.
As per PW2 with evidence.
Yes, Mr. Goswami.
One is very much clear, my lord. The cross part also, my lord. I am reading the
Hmm.
PW1, my lord.
Hmm.
আসামি দয়ে সেইদিনা মোৰ ঘৰলৈ গেটৰ ওচৰলৈ মোক আমি ধৰি মাতে, নাম ধৰি মাতে, মোক তাত লগ পায়, তেওঁলোকে মোৰ লগত ধমকি কৰি মাৰিবলৈ ধৰে, মোক বেয়াকৈ মাৰে, মোক তেওঁলোকে টানি নি কুলসিংহৰ ঘৰৰ ওচৰলৈ লৈ যায়, তাত কুলসিংহই মোক ধৰি ৰাখে আৰু আসামী শান্ত সিঙে মোৰ মূৰত ৰদেৰে মাৰি বাওঁ হাতত মাৰি হাত ভাঙি দিয়ে, শৰীৰৰ বিভিন্ন স্থানত মাৰি মোক বেয়াকৈ জখম কৰে, মই তেজেৰে লুতুৰি পুতুৰি হৈ যাওঁ, মোৰ মূৰত 7টা বেণ্ডেজ থাকে। Thereafter, my lord, he was admitted to hospital.
Hmm.
idea
অভাৱৰ কাৰণে কবিৰাজী।
কাৰণে মই চিল এতিয়াও ভাল হোৱা নাই। Lord Sime, kindly. Yes, denied
Okay,
every
fine.
transition.
Dinner. Hmm.
Here he was
Just have PW2.
PW2, my lord. Or Ekman Bozat, he said. Ekman Bozat, Assamie,
No, go come to the cross.
prosper. লিখি দিছ তাৰ ওচৰত মেল বহি, তাৰপিছত মেল বহিছিল, কিন্তু আছিলো আসামিগণ হিৰে আন কোনো আহে, স্বামী সন্তানহীন হৈ পৰিছিল। But in cross also,
Nothing is there.
nothing is
What
there.
do you say about the non-examination of the IO?
On examination, IO, my lord, regarding that, my lord, they've been examined, that is one part, my lord, but whether non-examining of the IO has cause any prejudice or from the evidence, my lord, because the victim statement, PW1, PW2, and the my lord, injury described by PW1 and also by victim himself, my lord, it stated very much clear that he was hit in the occipital region and his left
Broken.
hand is broken. Both side, my lord, and injury in left frontal region.
Injury report and the
And-
evidence deposition of PW1 and 2
Yes. So there is
corroborations.
no occasion that he could, my lord.
There was any doubt.
Any
Only the
doubt,
doubt
no.
is with regard to the timing, 1,
Yes.
1:30 and
1,
12.
130, my lord. That
So
is
after
my
5
lord
years,
discriminate-
maybe that's
that
your
discriminates-
argument. After 5 years,
Yes, because that the ground, my lord. and-
My lord, from
And-
the
yes, Mr. Singha.
my lord, from the evidence, my lord, as read out. So it is revealed that, my lord, there is some enmity between these two parties. And my lord, as my lord, my humble submission, since there is a not corroborated timings of the case, there is no other eyewitness, my lord, to my lord, prove the case whether that was happened or not. It is a mere allegation by the my lord accused persons, by the.
Now.
In that case, my lord,
Okay,
I was
fine.
in, my
You
lord,
say that there was no motive.
motive is not there, my lord. And one thing is that it is very clear.
Once there is direct evidence,
My lord, direct evidence from the victim as well as from the informant. Now they are husband and wife.
you had crossed them, you could not dislodge them.
No, my lord, that is there, my lord. My lord, my
There is nothing,
some-
what you are trying to now say, there is nothing there in the cross.
my lord, in the cross, they have already stated that there is some enmity.
That is different.
My lord, there is no other eyewitness that this incident was, my lord, as the assault was made by this accused
Mr.
person.
Sinha, if the criminal law is to be so construed that without motive, no criminal will be punished, even if there is direct evidence, and that section 134 or 124 Evidence Act, it's not the number of witnesses. Evidence Act, sir?
Yes, that's it. Yes, it is there in the.
That is only my submission.
So
Since-
if
since-
that be so, it's the quality, not the quantity.
My lord, my only thing is that since IO should be, my lord, IO has to, my lord, examine at that point of time to clarify all these things, my lord, because there is no corroboration regarding the timing of the incident. In that case, my lord, IO's examination is very much important.
And
And my lord,
Ah.
in 313 also, my lord,
Hmm.
there is nothing, all the questions were put to him.
he has
There
not
is-
even examined himself as a witness in the
Yes,
matter.
and also in 313, my lord, he has not taken that any enmity is there between them, so he has been implicated. Nothing of that sort. Also refer to 313, my lord. Every question has been put to him. He's only stated that it is false.
No explanation.
No explanation, my lord. Nothing, my lord. Marking the 313 statements, my lord.
No particular number of witnesses shall any case be required for the proof of any fact. Okay, we'll consider.
Yes.
But Mr.
My lord, regarding that age of the,
1 year only,
no, my lord, regarding this accused number one, he is already
we have not argued whether he should be given the benefit of the Probation of Offenders Act 1958. You have not argued. Mr. Goswami. This incident is of 2005. 20 years down the lane, right? 147. Done. Probation of Offenders Act.
Extend to 7.
But conviction will be maintained. Huh?
It is or not. It is not or, my. It is
Fine. No. It's not off.
or it's not there, my.
But it's together. That is there only in 417.
Yes, I have not found.
What do you want?
Some amount.
some amount, my lord, he was in the
Jail, my.
jail.
So that
No, that we will ask them to be. But if there is jail, that is gone. What time? How long were you there? Can you just check up from the records?
yes, just then it.
We'll limit it to that. See?
Yes, I am making it clear.
You okay?
Right.
Just give me a note on that.
Yes.
Heard Mr. K. Singha, learned counsel for the petitioner, also heard Ms. Mr. MP Goswami, learned counsel for the additional public prosecutor appearing for the state respondents. No? Eto khali মোৰ কাৰণে eto ita তোমাৰ order নহয়. Disposed of. Mr. Goswami find it, just give it to me. Or we will give him the benefit under Section 4 Probation Act. 20 years. Item kiman itu? Oh, that maintenance.
There was
Eto for my tradition.
present petitioner challenge before the Honorable Court. That matter was remanded back.
Hmm.
Remanded back, the was directed to at the matter, and the sessions as in the order granted
2 lakhs.
2 lakhs as an fair provision. That we have challenged. In the present case, by interim order dated 3/10/2000.
Have you paid the 3 installments?
Yes, we have paid. We have paid but all the payment receipt we have not received, but they have orally said that here, my lord, notice deemed served by order dated 4. But other side is not. This matter is ready.
We are taking it up for hearing only. This is a top of the list matter. It is for disposal. You can make your submissions.
Here, my lord, only ground is that the amount 2,000 has been awarded without 2 lakh was awarded without party petitioner is a very poor person. Able to he is only earning his earning is monthly 3,000 at that time as a driver.
Mr. Sigdar, that aspect was not brought on record. Your certificate that is there along with the patent petition is subsequent to the trial stage. WS আছে নেকি? WS para 11, he stated that at that time he was per month as a worker, as a temporary worker. But that was not established. And the evidence adduced by the opposite party, she was also not crossed. So that went on record as it is. That 10,000, 15,000 plus a car and a motor shop. This thing went as it is. Para 6. And therein this court has come, the trial court had come to a conclusion. Okay, fine. This is it. Done. Because it's only a prima facie satisfaction that has to be arrived at. That is there.
Of considering the financial status.
That financial status that has been considered is from the materials available on record. How can we today undo that? You're this certificate from some shop owner that you are his driver paid 3,000. This was never there. That man was not examined. If that man was examined, it would have been a different aspect altogether.
May
Nothing is there.
I
And Mr. Sigdar, this court had, while remanding back the matter, also given you the party's liberty to adduce further evidence. That you did not do. Rather, you agreed that whatever is on record, this court, that trial court should proceed on that. Come to page 41, para 3 in the middle. So,
para 3, my lord.
para 3 middle, to that effect.
To that effect, I have heard learned counsel
Both agree.
on the point that there is sufficient evidence on that court can assess and determine the amount of reasonable.
And there is no need to take further.
There is no need of taking.
This is your death knell. Heard Mr. A.R. Sigdal on a counsel for the petitioner. None has appeared on behalf of the sole respondent. So, the present revision
The
petition,
other side is not contesting the case, man.
that is for her. The present revision petition has been instituted assailing a judgment and order dated 06/2012, 18/6/2012, passed by the session judge Gwalpara in case number C.M.47/2010. So, the facts leading to the institution of the present criminal revision petition is noticed as under. The opposite party hearing, the respondent, sole respondent hearing, as petitioner, had instituted a proceeding invoking the provisions of section 3(1) of the Muslim Women Protection of Rights on Divorce (over) Act 1986 before the Court of the Chief Judicial Magistrate, Gwalpara, praying for maintenance as well as for payment of the agreed mahar amount, and also for returning the properties mentioned in the list attached thereto. The opposite party had also prayed for grant of future maintenance, that is for the post-iddat period, IDD 80 period. Also, the said proceeding was registered as MCR case number .MCR 355/09. Subpara. The learned trial court, on consideration of the matter, was pleased wide judgment and order dated 26/7/2010 to dispose of the said application inter alia rejecting the prayer of the petition for maintenance during the iddat period as well as for the post iddat period from the petitioner herein. The opposite party, the respondent herein was held to be entitled only to receive the non-paid portion of the mahar, of the agreed mahar amount from the petitioner herein. Full stop. Being aggrieved by the subpara, being aggrieved by the said judgment and order dated 26/7/2010, passed by the trial court, comma. The opposite party herein, or the respondent herein, assailed the same by way of filing a criminal revision petition before the court of the session judge Gwalpara. The said proceeding was registered as case CM number 47/2010. Also, the revisional court, upon considering the matter, was pleased with order dated 7/3/2011 to dispose of the same with a inter alia with a direction to the petitioner herein to provide a sum of rupees 2,000 per month to the respondent herein for the iddat period of 4 months, and thereafter for the post iddat period to pay a sum of rupees 1,000 per month to the respondent till she is remarried. The petitioner was also directed to pay to the respondent herein the deferred mahar amount of rupees 24,801. Words are ligidiba. Jot figure as a word koidiba. Also, subpara. Being aggrieved with the said decision of the revisional court, the present petitioner approached this court assailing the same by way of instituting criminal revision petition number 196/2011. Also, this court, a coordinate bench of this court, wide judgment and order dated 17/12/2011, was pleased to dispose of the said criminal revision petition inter alia by requiring the court of the learned session judge Gwalpara to assess and determine the amount of a reasonable and fair provision to be paid by the petitioner herein to the opposite party, and thereafter to determine whether the said amount should be paid at a time or in installments, which can be also made on monthly basis. Also, the direction of the learned session court wide the judgment and order dated 7/3/2011 for payment of rupees 1,000 per month to the respondent herein for the post-iddat period was interfered with. Also, accordingly, the subpara. In terms of the directions passed by this court, while the said judgment and order dated 17/12/2011, the matter was reconsidered by the Session Judge Golpara in case number CM 4710, and while judgment and order dated 18/6/2012 was pleased to determine rupees 2 lakhs as the fair and reasonable provision for future maintenance of the respondents herein by the respondent herein till the time she is remarried. Also, the learned session judge also directed that made necessary direction with regard to the return of the dowry articles and payment of equivalent amount thereon if the same is not so returned. Also, having determined the fair and reasonable provision for maintenance, the learned session judge had also provided that the same would be cleared by the petitioner herein in 8 equal monthly installments. Also, being aggrieved, the petitioner has assailed the judgment and order dated 18/6/2012. Being aggrieved with the judgment and order dated 18/6/2012, the present petitioner has instituted the present proceedings assailing the same. Full stop. Mr. A.R. Sigdar, learned counsel for the petitioner, at the outset has submitted that the learned trial court, while proceeding to ascertain the reasonable and fair provision required to be made for the future maintenance of the respondent herein, had not considered the evidences coming on record in the matter in its proper perspective. He submits that the determination of the fair and reasonable amount at rupees 2 lakhs, so made by the learned session judge, has been so made without appreciating the evidence of the petitioner herein, which, if so appreciated, would have brought to the forefront that the petitioner was only working as a daily labor and he was not in a position to provide for the said amount for the future maintenance of the respondent herein. Full stop. Mr. Sigdar has submitted that the opposite party, that the petitioner herein had in his evidence brought on record the fact that he was earning by plying a vehicle and did not have any motor parts shop as alleged by the respondent herein. Full stop. In the above premises, Mr. Sigda submits that the determination of the fair and reasonable amount for future maintenance of the respond number of the sole respondent as made by the impugned judgment and order dated 18/6/2012 by the learned session judge Gwalpara would mandate an interference from this court. Anything more? A mandate interference from this court or Agorata Lihiva. Mr. Sigdar has submitted that in terms of the directions passed by this court void order dated 3/10/2013 in the present proceedings, the petitioner has already deposited three installments out of the 8 installments as directed to be made by him by the learned session judge void the impugned order dated 18/6/2012.
My friend, he has already paid in the meantime.
Married,
We have not got on that.
if married after 8 months, then that will be of no effect. If married before 8 months, then you are saved. You show me that she was married within that 8 months, that installment period. Show me, I'll income because that's the law. Muslim law, it's still remarriage only. Then no material. This matter came last in 2020. Thereafter, nobody. Well, I've heard the learned counsel for the petition and also perused the materials available on record. Baki material. Any idea? Dismissed. We'll direct you to pay the balance installments. Not Gulni. Mr. Nat is there? Okay, after some time. MC criminal MC 8120. In view of the order passed today, no order is called to be passed. And I could dismiss. Yeah.
13.
Yes.
Court number 1. The court matters as in count.
Yes, Mr. Mahajan, what did you get?
I beg my lord, part my lord was not then.
Huh?
For part 2, my lord. Here's 3 months, my lord. Because she surrendered on 4/1/2012, my lord. Got bail on 7/4/2012, my lord. Of around 100 days, my lord.
He was
Surrendered on 4/1/2012, my lord.
4/1/2012 surrendered.
Bail he got on 11/4/2012.
11/4/2012. So he was
100 days, my lord, around 100. My lord, after the judgment, my lord, he was on previous bail, 29/6/2013, my lord. And this high court granted him bail on 23/9/2013, my lord. My lord, only one witness is there, my lord, PW8, my lord, the daughter.
solitary witness.
Yes, my lord. So what I would submit in this case, my lord, is that had no intention to kill the deceased or even cause such injuries that likely course of him
Mr.
could
Mahajan,
die.
Mr. Mahajan, just for my understanding, the incident is not in the evening. The starting is not in the evening. Starting is in the morning. He goes back, comes back with a bamboo stick, and
The
he
bamboo-
assaults the mother of PW8. Right? Sudden provocation is not there. Sudden provocation is not there. From the materials coming, even in your 313, you have not said that. Sudden provocation is not there. What had happened in the morning, he had time. So, it was a case of 302 part 4 part 1.
How long may the gap may be, my lord? It is from up with the other daughter, my lord.
Go sit, go through it.
On record that, my lord, he was insulted for a long period of time, my lord. What I would say, my lord, is that his was grievous injury, maybe, my lord, because he came back with a lathi. Cow herder possibly, my lord, may have a lathi on him, my lord. It is not hit her. There are 4 injuries on her body, my lord. They are on the lower parts, my lord. One fortunate injury is on the head, my lord. Would submit is that, well, his intention was to cause all the insults or hurt or grievous hurt to the lady, my lord.
Not to kill. So 302 is out of the way.
Can be committed under 320. That effect, my lord. Or even to cause such injury that in ordinary course of nature she would die, my lord. It is also in the judgment, my lord, that had she been taken to the hospital, my lord, she would have survived, my lord. That lordship will find out, my lord, page 18, my lord, inner page 18 of the judgment, my lord. Para 51, my lord. It appears from the evidence on record that the accused used a stick while assaulting the deceased, which cannot be said as murder or weapon. We've also seen that after the incident, deceased was taken to pharmacy when a bandage was applied, wrapped in the head. She was not taken to hospital for treatment, so negligence to treat the wound being a contributing factor. Proper treatment, she may have survived.
That's true.
Question is that, my lord?
But see the next paragraph.
Yes, my lord.
Next sentence.
Yes, though an intention to cause death or such bodily injury is likely to cause death.
No. Though the intention to cause death or such is likely to cause death cannot be attributed to him. Knowledge is attributable that an injury by a stick on the head was likely to cause death. Now read. As the incident happened on sudden quarrel.
There was
no sudden quarrel.
Immediate quarrel is not there, my lord.
There was no quarrel at all.
It is said that the mother injured her.
Her.
And
He took it to him. That's a presumption. That was not even there from your side, from the accused side. That was not.
It's mensia, my lord. Is that even if somebody says something,
That because of the
that
eloping.
can be convicted of 320,
Hmm.
40 to 325, my lord.
So to that extent,
Converted, my lord. I'm a humble son.
IPC 2.
Incident is of 2011, my lord. That time the informant was of 65 years of age, my lord. W1, my lord.
This man is also now, I think, he'll be also old.
There are 2 and 3, my lord.
Hmm.
There. 7 were on the lower arms and legs, my lord. Honorable Supreme Court said that the intent is hurt, my lord, and not death. It was 325, my lord. It undergone, my lord.
Okay. Yes, what do you say?
Yes, my lord, punishment is, my lord, I think it is nominal, my lord, because it is only 3 years. My lord, sudden provocation is not there, my lord, and he came after, my lord, with, my lord, some preparation, my lord, with a bamboo.
Hmm.
And then, my lord, he said, and my lord, it is injury is on the, was on the head, my lord. But, it is a common knowledge that, my lord, when
There is a
Yeah.
decision, latest decision of the Supreme Court,
Well.
how to correlate between an injury and a subsequent death, whether that is the cause or not. Here, the problem is
Yes,
that injury was there,
well,
but she was not treated for that.
yes, my lord. Only, my lord, pharmacy treatment.
Pharmacy treatment was made.
That part is also there, but, my lord, it is.
The submission made by the amicus is that it is a fit case which can be
Yes.
converted to 325 and
325.
then limited to the 100 days he is already behind
Yes,
us.
that issue may be considered, my lord, but
Okay, done.
head injury.
Thank you, Mr. Masu.
Obliged, my lord. Highly obliged.
Dispose of. Ajay Sapak Woody Markutli back like it. Yes, Mr. Nath. Nath of Mati.
Asked me to see
Ah, ah, ah,
in
ah.
item number 4 regarding that, man. My lord, what happened, my lord, on 21 of the miss case, Lordship, may kindly see miss case number 658 of 2013, my lord. That,
Hmm.
in that case, my lord, on by order dated 25/9,
Hmm.
Honorable Court directed him to surrender as he has not surrendered
Hmm.
after getting the, my lord, conviction, my lord.
Hmm.
So Honorable Court directed him to surrender,
Hmm,
and
hmm.
thereafter he has surrendered.
Then a bail was granted.
Then thereafter bail was granted, my
Hmm.
lord. Already, my lord, he is
Not much.
not much, my lord, but that period can be considered fine intact, my lord.
Conviction is 325.
25.
The only worry is 20 years down the lane.
That
Okay, we'll find out. Thank you.
was
Yes, Mr. Nath.
2025.
Huh.
Person to that lordship, the promotion access, the order has been issued, my lord.
Oh, very good. So you have been promoted.
My lord, my humble sub that number 3 in the promotion order itself given that he'll be in charge.
Okay.
One thing. Second thing, there's really one promotion. I have been transferred from Silchar to Dibrugarh, and the others all have been transferred from their place. It is a promotion.
Hmm.
He has been kept here. I don't know how the respondent number
No, I have-
is
I have
giving so much
given-
favoritism to the respondent number 3,
I have-
and in violation of the rule.
Mr. Nath, when a pressure cooker is on, you must permit it to the whistle to blow.
My lord, being a senior most, my lord, I last 2 years, 9 months, my junior is dictating me. And my lord, I have it there, he has collected SCRs of everything. He's entirely interfered in the selection process. I have the order, my lord. He has said that you collect the SCR, and a junior, being a junior, he is collecting my SCR. They totally interfered in the selection procedure. Here is the, my lord. So my humble submission is whether Rule 12 will be allowed to be permitted to be violated by them, because they have promoted under the rule, the 309 provision rule. And last 2 years, 9 months. Directed, they collect the ACRs of all the subordinates. I know, my lord, state should be the, my lord, impartial to all officers. Why the respondent number is giving so much favoritism to the respondent number 3? I don't know. 2 years, 9 months violating. And my selection, my recommendation was in the year 2019, 2020, 2021. And I submitted representation on the year,
What is your name?
my Lord Kamal Das last man. He has been transferred from Silchar to Dibrugarh.
No, your name, your name.
My Lord, my last serial number 4 in the promotion.
Kamal Das.
Kamal Das.
You are Kamal Das.
Yes.
And,
Lord, this
who is? Oh,
Sikar-
Kamal Chandra Das.
Kamal
Okay.
Chandra Das.
And this one, Subroto Mojumdar?
Even my name is wrongly written. My name is also wrongly written.
Where?
I am a Kamal Chandra Das, not Kamal Das.
Okay.
Yes,
Don't accept your
case
promotion.
Regarding me, I don't know, my Lord.
Subroto Mojumdar is?
My Lord, no, my Lord, the item 15, 16.
Kindly take up 15.
Fif-
Item
15.
15.
No, what is Subroto Mojumdar?
My Lord, he is a, my Lord, the LD.
LDA.
LD.
That he is for against him, it is the departmental proceedings.
Proceeding and suspension.
Okay.
In that case, my
Okay,
Lord.
we'll deal with it. Now we'll have to take up Kamal Das. Okay. Kamal Chandra Das.
And in promotion order, my name shown Kamal Das.
Hmm.
This is on contact of the respondent number 1. It's okay.
Mr. Monto, this is bad. You should write Kamal Chandra Das.
Because only thing is made by Lord. Rule 12 is
So your this prayer with regard to your promotion
Yes.
is done with?
prayer, my Lord 1.
Or B is done with?
And with my Lord, command allow the petitioner to serve as officiating ad hoc inspector by chief inspector
Till
of
the
Board.
post of is filled up on
Filled.
regular basis. So this is pending.
Pending.
And what is pending is setting aside, what is this notification?
Setting as
Annexure 4 and
by which he was made in charge
in charge.
in the year 2023.
Okay.
And
Okay. So that is gone now. 4 and 6 is gone. Because a fresh agreement has come into being. So we dispose of this writ petition by directing the respondents, now that the incumbents are there in the post of senior inspector of boilers.
has been one thing. Yes.
What we direct is interim arrangement is again for the state to consider. We direct the state, the government, we direct you to file a representation giving all your particulars. The government will take that into account and pass appropriate orders with regard to holding of the charge of the post of Chief Inspector of Boilers. Till that decision is taken, respondent number 3 will continue. Decision be taken within a period of 1 month. Done? Disposed of?
I have, in any case, Lord, I have given the agenda note and the minutes of the deal.
I'm only concerned with your
Lord.
this thing.
Promotion order. Lord.
Any objection in that order being passed, Mr. Mohanto? That is done with?
Only, my Lord, I will submit, my Lord,
Lordship,
only
Lordship.
I will submit a representative. My contention is that since last 2 years, 9 months, he is on promotion also, he has been kept in the same.
No. We say that that is a temporary arrangement. Decision will be taken considering all in terms of the rules that are holding the field after you file this representation.
Lordship.
Done?
Lordship.
Agreed?
My Lord.
No grievance?
My Lord.
Everything has come out?
No grievance. My Lord.
Heard Mr. S. Nath, learned counsel for the petitioner. Also heard Mr. D. Nath, learned senior government advocate appearing for the respondent number 1 and 2. Also heard Mr. P. Mohanto, learned counsel appearing for the respondent number 3. So, the present writ petition was instituted by the petitioners, by the petitioner herein. Praying for the following reliefs. Page 16, A to A. 16 and 17, A to A. Also, A to A. Also, one of the a perusal of the reliefs prayed for by the petitioner would go to reveal that he had also sought for a direction upon the respondent authorities to consider his case for promotion to the post of Senior Inspector of Boilers. Also, on the earlier dates of listing, Mr. S. Nath, learned counsel for the petitioner, had, by referring to the materials brought on record, submitted that the post of Senior Inspector Boilers were lying vacant in the establishment. However, in spite of repeated requests made, the authorities had not proceeded to initiate steps for filling up the post of Senior Inspector of Boilers.
Submitted a representation 20 for in charge, for in charge. That may for in
Name
charge.
is promotion. In charge is nothing.
Boilers.
Also, Mr. Nath had further raised a grievance with regard to the action on the part of the respondent authorities in permitting the respondent number 3 herein, who was also at the relevant point of time incumbent in the cadre of Inspector of Boilers, to hold the charge of the Chief Inspector of Boilers without considering the case of the petitioner herein for similar appointment. Also, post with the said, considering the said situation, this court had required Mr. D. Nath, learned senior government advocate, to apprise this court as to why the promotions to the post of to the vacant posts in the cadre of Inspector of Boilers, existing in the establishment of the Chief Inspector of Boilers, were not being filled up. Although initially a submission was advanced that the rules holding the field, that is the Assam Broiler, BROILER, Service Class 1 Rules 1975, was being reconsidered and a new rule was being contemplated to be formulated in the matter, regulating the service conditions of the officials in the establishment of the Chief Engineer of Boilers. However, subsequently, Mr. Nath, on instructions, had submitted that the respondent authorities would carry forward the selection process strictly in accordance with the provisions of the Assam Broiler Service Class 1 Rules 1975. Also, this court, wide order dated 28/2025, noticing the said submission of Mr. Nath, had granted liberty to the respondents to take the matter with regard to promotion of the eligible incumbents to the cadre of Senior Inspector of Boilers to its logical conclusion. Subpara. Today, when the matter was called up, Mr. Nath has placed on record a notification dated 12/9/2025 issued by the Labour Welfare Department promoting the incumbents whose names have been set out therein, including the petitioner and the respondent number 3 herein, to the post of Senior Inspector of Boilers. Also, Mr. S. Nath and Mr. P. Mohanto, learned counsels appearing for the respondent petitioner and the respondent number 3, respectively, have submitted that in terms of the said notification dated 12/9/2025, they have assumed the charge of the promotional post. Also, in view of the issuance of the order dated 12/9/2025, the grievance of the petitioner or of not being considered for promotion to the cadre of Senior Inspector of Boilers stand redressed. So, where is that order that he should be continuing to take charge of?
My lord, that writ petition in the
No. In the new order, where is the thing that he will continue to take charge, remain in charge?
here, my lord. Headquarter. He has been kept in the headquarters.
Oh, there is two. Sikandar Ali is also kept in the headquarters.
No. Sikandar Ali brought from my lord. That is why they have not placed mention. He was in the Sikandar Ali junior most transferred
Okay.
from my lord Shivasagar.
Okay.
Sikandar Ali from Shivasagar.
Okay.
It is what not mentioned.
Mr. Nath at this stage submits that his grievance for being also given the charge of the post of Chief Inspector of Boilers have not been redressed by the respondent authorities. Also, he submits that the earlier arrangement as made with the respondent number 3 as the in charge Chief Inspector of Boilers would now require to be reconsidered on the petitioner, respondent number 3 and other incumbents in the cadre of Inspector of Boilers being promoted to the cadre of Senior Inspector of Boilers. Also, in view of the above position and the respondents also being required to take a decision with regard to the person who would man the post of Chief Inspector of Boilers before the same is so filled up on regular basis, this court requires the petitioner herein to submit a detailed representation before the principal secretary to the government of Assam, Labor Welfare Department. It's under the Labor Department. Labor Welfare Department, staking, S-T-A-K-I-N-G, therein a claim to be allowed to hold the charge of the post of Chief Inspector of Boilers till the said post is so filled up on regular basis. Also, the respondent number 3 as well as the other incumbents in the cadre of Senior Inspector of Boilers are also at liberty to submit individual applications staking their claim for holding the post of holding the charge of the post of Chief Inspector of Boilers. So, on receipt of such representation, the Principal Secretary, Labor Welfare Department shall consider the same and pass appropriate orders towards allowing the eligible incumbent so found to hold the charge of the post of Chief Inspector of Boilers. Also, the said exercise be so completed within a period of 1 month from the date of receipt of representation from the petitioners and other incumbents in the cadre of Senior Inspector of Boilers. Also, till the said exercise is so carried out, the present arrangement made with the respondent number 3 as the in charge of the post of Chief Inspector, present arrangement made with the respondent number 3 as the in charge Chief Inspector of Boilers shall be permitted to be continued and will stand superseded with the orders that would now be passed by the Principal Secretary to the Government of Assam, Government of Assam Labor and Welfare Department in pursuance to the exercise required to be carried out as above. Also, anything more? That as per rule only. In accordance with law, as per the rules. Full stop. Just a moment. Full stop. As the incumbents have already joined the joined the post of Senior Inspector of.
Not joined.
You have not joined.
12/9, my lord, on the Friday.
Full stop. As the promotions have now been effected to the cadre of Senior Inspector of Boilers, which is the feeder cadre for promotion to the post of Chief Inspector of Boilers, this court provides that it would be open to the respondent authorities to take appropriate decision for considering the cases of the incumbents in the cadre of Senior Inspector of Boilers for promotion on regular basis to the cadre of Chief Inspector of Boilers, if required, by also invoking the provisions of Rule 29 of the said rules of 1975. Relaxation is there, invoke it, do it. Also, with the above observations and directions, the present writ petition stands disposed of. That will be a separate exercise. Separate exercise. I provided that. Only this. I say it is also provided that you can do it if you want it. Wish to. Because advocacy is not to be.
Rule also, my lord, Rule 12 also does not permit more than 2 years.
You come back after 2 months. Whom should I put it? Additional Chief Secretary, Labor and Welfare Department.
My lord, in item number 15, my lord, 1 and 2 has not submitted their affidavit.
No need.
No. Because
One is item number 5846 24 khali disposition. Now come to 1758.
my lord, suspension order, he has made the suspension order.
Has the suspension order been validated by the authorities? Mr. Only thing that much only. Mr. D. Nath, learned senior government advocate, submits that he be granted 2 weeks time to complete his instructions in the matter. Full stop. Prayer is not objected to by the learned counsel for the petitioner. In view of the above, registry to list this matter after 2 weeks on a date to be fixed by it. Also, the matter shall not be treated as a parted and or tied up matter with this court any further. Mr. Nath, this is not maintainable. This is possible. The issuance of a notice by an authority lower, it is possible. Because if this was troubling me a bit. No, this was troubling me. Subject, just my thought process, you would think. 311 says if it is removal, reversal or compulsory retirement cannot be by an authority lower than the appointing authority.
That is a fact.
But that prescription, whether will apply at the start of initiation.
Yes, I understand. My contention is that Malafide is there because when Shokos said, I am making conspiracy to remove him from in chargeship.
You're a powerful man.
Yeah, powerful man. That is why Malafide exercise is there, my lord.
Oh, okay. Copy of the upward likhi bade এইটো যাব এইটো ডিসপোজাল এইটো থাকিব কিন্তু once no copy of the order dated 12/9 notification dated 12/9/2025 along with the agenda note and the minutes of the selection committee meeting as furnished by Mr. D. Nath is kept on record and marked as X for the purpose of identification. X বলে লিখি কেনে মই কি কৰিম?
Obliged.
Separate হৈ গৈছে এতিয়া separate কৰি দে হা তাতে আপোনালোকে
This matter was filed long back, but this was not admitted, Lordship. But records are here. Here, facts of the case is complainant lent some money to an NGO for a benefit of the NGO. And subsequently, Lordship, the present petitioner, along with the secretary, issued a check which was maintained in the name of the NGO. And that was bound. So now he has lost the case against the present petitioner and the other secretary, Lordship. And my humble submission for Lordship is that in view of section 141 of NI Act, he has to make the NGO a party as a prime accused, Lordship. And non-implementing the company as a prime accused, the present Lordship
that was gone into by the
so that aspect is wrongly gone into by the trial courts. Lordship,
the projection made is thus to bring it out from 141. The projection made was that the money was sought for by the accused 1 and 2. Evidence.
I'm sorry.
1 and 2. And when the money was to be returned, they gave a check of the NGO. Right? He took that check, but the burden is not towards the he has not given the money to the NGO, but to accused number 1 and 2.
Probably in my humble submission is contrary to the record. Record reveals that it was given to benefit of the NGO in the evidence, the evidence of the complainant. Lordship, may kindly see.
That you show me. Mr. Alam, if that is the thing, if there is a statement, then there is a statement on your part.
Yes.
That you had given the money to the
benefit of
I wanted it to come out from his mouth. It has come out now. That towards the end of the PW's statement, or sorry, accused statement, there is an averment that this money, no, your statement, sorry, PW, your statement that this money was given to the NGO.
Column number 3 of his evidence, Lordship.
Yes. If that be so, no. There is an evidence.
Just I'm reading that part,
Wait. No. That is secondary. But the first evidence is I have not submitted any document to show that the amount of so-and-so was taken by the accused person.
Column number 3, Lordship, may kindly see. First 3 lines.
Column number 3?
Of his additional evidence in chief. Evidence from chief. Para 3.
Additional evidence in chief.
Evidence on affidavit. Evidence on affidavit.
Affidavit of Pranjum Kolita.
Yes, Lordship.
Para 3.
Para 3.
So-and-so met and they approached me personally for financial assistance of their NGO.
NGO. Yes.
On several, and out of the so-and-so, I gave an amount so-and-so in presence of so. Now, in your income tax returns, whether this amount is shown to be given as a loan to the NGO or...
And last...
No, Mr. Alam, this amount was given as a loan to the NGO in your... Because you have referred that this I have although I should have given him a check, I have given him cash, but it is reflected in my returns. In your return, is it a loan to the NGO or to the? Hmm. So, what decision, is there any decision supporting you in this connection? No, his case is, no, that aspect cannot be put in his mouth, because his case is that the check was given to you by the deceased accused. He had got no knowledge of that. He went to Madras, he came back, he found that he had signed, he is the secretary, I think, signed some checks. The other one in a conspiracy with you had utilized that check. No,
He himself.
no, Mr. Alam, the problem here is that a situation does not arise because he has said that money to forget it, this check was not, there was no transaction.
And to that effect, cross-examination is also there.
Any decision to that effect? Can you? He is trying to bring your case within 141. Accused person. And that has been accepted by the court also. Okay.
And that money was given.
Go little bit.
There was no transaction. After that money was
Dictation দিব লাগে না স্যার তা দিল এটা আছে The learning counsel for the parties at length registered to list this matter again on Thursday. Find out something.
I did not get.
But there is an evidence also in your cross also, in the evidence cross also you have said this. Just go through that once. No, I got it. But in your evidence, in your cross, there is a line, and the main also, chief also, there is a line.
Is that it was given to it. They have.
Okay.
Lordship,
Thursday.
When there is admitted part.
Thursday. But these things are just tentative.
Lordship, I understand.
I can go either way. So
Absolutely.
just
That I
trying to
understand.
formulate my thing.
The further-
So you also, just by saying will not do, you also prepare, let me know that
Some-
this is the thing.
So I will place.
Mr. Alam, if there is any judgments, please share.
Have some judgment, should I place today before?
No. Next day, if you
Lord.
can give a copy, if you have, thus it will be put in the file.
They have their case.
They have case. That's the issue which I am trying to understand. Okay.
Oblige, Lordship.
Yes, Mr. Doctor.
I've talked with him, maximum he can pay, let's say, within a month, let's say, 3 lakhs. That was the. Leaving it to here.
So we are dismissing it. You already moved,
Yes.
but we are dismissing your petition.
Lordship.
And you will pay this amount within a period of 1 month, whole amount. Otherwise, you can initiate steps.
No, Lordship, this is my writ petition, Lordship.
This is a writ court. 226.
But Lordship,
Where there is illegality, I'll come in. Appeal is there.
Lordship,
Appeal is there.
Lordship, so far as bill is concerned, Lordship, that is in dispute, Lordship. Bill is in dispute.
We say this is not maintainable. And that they have now said, and you are trying to take advantage of it.
No, Lordship, bill.
This is public money. You are using public space.
Yes.
You earn from that. Now you are required to pay. If you're not pressing it, I'm not going in. But if I go in, I'll be going in hollow.
And I may be allowed to.
Mr. U. Dotto, Mr. U. Dotto, learned counsel for the petitioner. On instruction, submit that the respondents have furnished the detailed breakup of the monthly rent claimed from him with effect from June 2017. However, for the period prior thereto, they have not made any. They have not furnished any breakup. Also, in view of the above position, this court, the petitioner submits that he be permitted to withdraw the present writ petition. Also, prayer is not objected to by Mr. Chamaria, learned counsel for the respondents. Full stop. Accordingly, the present writ petition stands dismissed on being withdrawn. Full stop. There is no interim order. It is provided that the respondents would be at liberty to proceed in the matter for recovery of their dues strictly in accordance with law. I wanted you to do this last time only. You did not.
That client is hesitant, Lordship. I on my own, Lordship, cannot.
Yes, isn't it? Yes, Mr. Monto. Been having a very busy day.
Sorry, my lord, court number 1, my lord. Lots of my lord, High Court matters are.
No, I understand. We'll have it on a different date then.
My lord, even, my lord. Defended.
When? Day after? Whenever you're free. You're here
Thursday, my lord.
Thursday.
10 days conviction, your lordship, from very beginning, I am denying, my lord. I have not received notice, I have not received notice, my
I
lord.
think that is what I told him. But pinpoint now. Just pinpoint it. Date-wise. Make a small note. Date-wise.
Exactly, that's why I want to prepare it, my lord.
Heard Mr. T.J. Monto, learned counsel for learned senior counsel appearing for the petitioner, assisted by Mr. Heard Mr. T.J. Monto, senior advocate, senior counsel, assisted by Mr. T. Gugoi, learned counsel for the petitioner, and Mr. R.J. Burwa, learned additional public prosecutor appearing for the state respondents. Also, heard the full stop. Hearing remains. The parties have made their respective submissions. However, the hearing remains inconclusive. A registry to list this matter again on Thursday, 18, for further hearing.
My lord.
You also go through the evidences once.
I have gone through, my lord. I have gone through. My lord, one fact, my lord, he cannot deny, my lord. He being the OC, my lord, was sent to my lord, IGP, my lord. There are instances, my lord, who when my lord, I know the police inspector, my lord, who was an IO in the my lord case.
To my learning,
That case, my lord. And information to the my lord, the superintendent of police or the DIG, my lord. They have got the list of all the officers, my lord, where they have been posted, my lord.
You just clarify one thing. We'll 10 days, we'll put him inside. Just clarify one thing. The notice had gone to the DSP. From the DSP, she says, I gave it to the reserve officer. Reserve officer says, I have sent it. And he received it. Sending, there is proof. Just find out if there is a receiving, because his signature was doubted. And the plea taken is that he, having doubted, he should have asked for the reference to the FSL. The prosecution should have established that aspect of the
Yes.
matter also. Just,
That is the.
Mr. Monto is trying to mislead me there. You find out that.
No, I am not trying to mislead, but I am trying to lead your lordship, my lord. From my own knowledge, my lord.
That leading, see,